Eku Iluna, please rise. Auhea oko e ko ka aha inahe kuliana imua o kia aha ho kolo ki ike e hano o ko moku aina o Hawaii. E nai mai, e malio mai, I lohi ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho I lalo. Please be seated.
Please call our case.
Case number SCWC-23-0000376, State of Hawaii, Respondent/Plaintiff Appellee versus Charles Zuffante, Petitioner/Defendant Appellant. Arguing for the Petitioner, Charles Zuffante, Georgette Yandel. Arguing for the Respondent, State of Hawaii, Frederick Makapinlock. Argument on the merits.
All right, good morning and aloha, everyone. The court's honored to be here today at the University of Hawaii Hilo Performing Arts Center as parts of the Courts in the Community program. Today's proceedings being broadcast live on our YouTube channel, as well as on Olelo and Naleo TV. Counsel, are you both ready to proceed today? Yes, all right, we've allocated 30 minutes for each side for argument. Just to confirm, Ms. Yandel, you'll have 20 minutes. We'll give you a warning light at that time, so you can reserve 10 minutes for rebuttal. Mr. Makapinlock, 30 minutes. We'll give you a warning with 5 minutes to go. Please proceed.
Good morning, Chief Justice, Justices, Counselor. Petitioner's Counsel stands respectfully before this court today, prepared to address the following. Why State Kekona was wrongly decided, and why Petitioner's case is the right case for this court to act to overrule it. Why the new rule requiring electronic recording of interrogations announced on review should be afforded retroactive application. What the new rule can and should provide. And finally, why the trial court in ICA erred in failing to apply State v. Ugolino as persuasive authority in determining whether or not the state put on evidence before the jury that sufficiently alleged the substantial step conduct element of the in-show offense Petitioner was convicted of. Thank you.
Please stand more closer to the mic, just in front of it. It's fine. You're doing, yeah, there you go. Thank you.
In 1994, Kekona came before the Supreme Court for determination. All the reasons why Kekona was wrongly decided is included right in the majority opinion. Justice Levinson pointed that out overwhelmingly in his concurring and dissenting opinion. The majority itself starts off with, undeniably, recording a custodial interrogation is important in many concerns. A recording would be helpful to both the suspect and the police in obviating the swearing contest, which too often arises when an accused maintains that her constitutional rights to remain silent or requested an attorney and the police testify to the contrary. What's different a little bit in Petitioner's case is he contests the content of his statements. If we take a look at our statute, which was promulgated back at the time of King Kalakaua's laws, which says that the voluntariness of a statement must be proven before the bench that is going to handle the trial before trial to show the voluntariness. But there's nothing in that statute that talks about how do you prove the content. The court went on. A recording would also help to demonstrate the voluntariness, the context in which the statement was given, and also, of course, the court says, the actual content of what was said.
Can I ask you, you're advocating for the Stephen rule? Is that what you're...
Not expressly only what's contained in the Stephen rule. Having 30 more years of technological development and experiences, including before this court.
But even with that rule, feasibility is one of the elements. And it's not as if the officer wasn't trying to record. He did want to record, but the equipment was broken.
We don't know if he wanted to record.
That's what he said. There was no real controversy on that.
Well, that's what he said, yes, Your Honor. And he also...
Was there any evidence to the contrary, that the equipment wasn't broken, unavailable?
No, there wasn't, other than the fact that that is a patently absurd statement, that it was impossible to record not only Petitioner's interrogation,
was
but
the
that of
officer
his
cross-examined on that? Was that challenged?
It was challenged, but not in depth. One of the reasons it was not challenged in depth is because it is patently ridiculous. Mr. Zuffante was in custody overnight the night before. Justin Gaspar came to work the next morning, according to his testimony, at 6:30 in the morning. He waited until 9:30 that night after Petitioner and his girlfriend had been held. No Miranda warnings ever given. What's the exigent circumstance? He first interviewed...
But shouldn't all those arguments have been made before the trial court?
It should have stopped at state's motion to determine voluntariness of the defendant's statement. At that point, that is the point at which trial counsel raised the issue, one, the lack of a recording is equivalent to lost or damaged evidence. The requirement to preserve evidence, what an easy way to avoid the requirement to preserve evidence if you don't create it.
Excuse me, wasn't KCONA in effect at that time, and what was a trial court supposed to do if there's controlling Supreme Court precedent that said a recording wasn't required?
The circuit courts are empowered by their plenary powers to promote justice in all matters before them. There is provision in statute that should a trial court move to disallow an alleged statement, the state is free to file for an interlocutory appeal and then bring it up where it belongs as a matter of constitutional constitutional law, with this stale opinion from 1994 still hanging around. At the motion to determine voluntariness of the defendant's statement, again, the title of that in and of itself is wrong. Voluntariness only. What about the content?
You know, can I switch back to touch on something Justice Devins mentioned? Now, it strikes me you're not necessarily arguing for the Stephen rule with regard to feasibility, that you are simply saying that in-station custodial interrogation, if it's unrecorded, violates due process. Is it my understanding that that's what you want, not to adopt the Stephen rule itself with its feasibility component?
To address the feasibility component in
well, there'd be no feasibility component because it can never be feasible. Isn't that your point?
Well, thank you, Your Honor. The point is that if it's impossible to video record, which is really what should be required in 2025, then it stops until there's an opportunity to indeed interrogate. There should be an exception for exigent circumstances, and state should have a burden of proof that is beyond a reasonable doubt to prove exigent circumstances. And that should be done at this motion to determine voluntariness, and hopefully we'll get an amendment at the legislature of voluntariness and content. Under Hawaii state law, we recognize that the burden on the state at a motion to determine voluntariness, it's recognized as heavy. And in Kaylee Colio, it was stated that it's particularly even more heavy after the person has been arrested.
Counsel, most of the states that require recording of custodial interrogations have implemented that requirement via either statute, so the legislature has an opportunity to study and consider all of the various issues that surround this important issue, or by court rule. After, for instance, a court committee has an opportunity, and their different rules have different requirements as to what the exceptions may be, what the requirement is, what kind of crime you're going to require recordings for. So Stephen is the only case in the country that has done it by court case under due process. How do you address that?
Thank you, Your Honor. In the amicus brief, it explained that actually 25% of rules that requiring electronic recording have actually been promulgated by Supreme Courts of those states.
But by rule, not necessarily. So that would be utilizing, for instance, this court's supervisory powers, right?
Yes, supervisory powers, or decided on the constitutional basis, which this court has a proud legacy of recognizing our state constitution as distinguished. In Justice Levinson's dissent in Kekona, he himself at that time recognized 16 cases where the language of, and this court has never hesitated to extend our constitutional protections beyond what is to parallel Constitution provisions in the Federal Bill of Rights.
My concern is what you're asking us to do. I completely understand the significance of what you're asking. My concern is we have nothing in this record, in this case, where you're asking us to overturn Kekona and set requirements, and what I think I heard is exceptions as well, without input from the police department, from other stakeholders as to what are the potential consequences of such a requirement, and the downside in terms of, for instance, making sure that we're not unduly tying law enforcement's hands.
Law enforcement is well equipped today with a myriad of means to record interactions, including interrogations. Body-worn cameras are very common. The police have in their car, in their subsidized vehicles, laptops. The opportunities for recording are ubiquitous.
So let me ask you this. In Stephen, the requirement was to record when feasible when in the police station.
Yes.
So what is your position on that?
That, well, if I may, we propose, Mr. Zuffante proposes a rule that video recording of suspect interrogations is a requirement of fundamental due process, guaranteed the criminally accused under the Constitution of the State of Hawaii. A video recording is a reasonable and necessary procedural safeguard, essential to the adequate protection of the accused right to counsel, to remain silent, and ultimately to a fair trial. That language is borrowed directly from Justice Levinson's recommendation.
Are you limiting that to in-station custodial interrogation? Because it strikes me that oftentimes interrogation occurs in the field, whether it's in residences, roadways, parks. We have body cameras, as you say now. We have phones. Are you suggesting that it's a fundamentally unfair trial if there is a custodial interrogation outside the station that's unrecorded?
No. There is provision in our proposed rule for exigent circumstances, and that would be such of one.
Well, why would it be an exigent circumstance for a custodial interrogation outside the station? That doesn't comport with what we normally think of as exigency.
Your Honor, Petitioner agrees, however, leaving room for, if there is an exigent circumstance where video recording was not made possible, then the state should come forward with sufficient facts to prove that.
Isn't there a logical inconsistency with your supposition that it's fundamentally unfair to do in-station custodial interrogations, but it's still cool to do outside the station interrogations?
Oh, there's no, forgive anything that counsel may have said to say that there's a position against in-house custodial.
I think here's where your response is. A police station is an inherently coercive environment.
Absolutely. It is absolutely inherently coercive, which is why we recommend that when interrogation takes place in a place of detention, that the video camera will be angled in such a way so that all participants are visible.
Along those lines,
sorry.
It's a little bit unclear to me when Officer Gaspar testified that the recording equipment was not working, and that's why he didn't do a video or an audio recording. What was the equipment? Was it a video or was it an audio? And was there any testimony as to if the video wasn't working, why it wasn't at least audio recorded?
Your Honor, there was no testimony about whether audio was an alternative. However, Mr. Zuffante did testify that he saw in both Officer Gaspar, the camera was visible in the room. Mr. Zuffante testified he presumed it was on.
In this case, you said that this is a good case to address this issue, but it really, how is it that the record here is developed enough to really be able to have actual facts in terms of whether it was feasible or not, why it wasn't on, why it wasn't running, what else could have happened? Actually, and I think the state is going to argue this, except for with one exception, Mr. Zuffante seemed to not dispute what was said by the officer when he testified. So why is this a good case for us to address this issue?
There is a dispute, but it is settled in the trial transcripts, which shows where there is agreement between Officer Gaspar and Petitioner. They do agree that Petitioner said, everything in the car is mine, I don't want the girlfriend getting charged. They agree to that. They also agree that Mr. Zuffante said, oh yeah, I sold drugs in the past. That's the only agreement. All the language about how much whatever cost, how it got packaged, how it got distributed, Mr. Zuffante, that actually is when he erupted during the trial proceeding.
But he didn't erupt during his testimony about that. In fact, he didn't testify about that. The only distinction between what he said and Gaspar said was all the meth in the vehicle. And I note that that's what Gaspar said in quotes in his police report. So it wasn't like that was an unexpected testimony from Detective Gaspar. So didn't that discovery alert the defendant to his informed decision on whether to testify or not, which I see is your key point here, the infringement of the right to testify or not to testify, to combat an unrecorded statement. But in this particular case, he knew what Gaspar was going to say, and Gaspar said it. How do you respond to that?
The motion to determine voluntariness, that is where everything should have stopped. The court entered findings of facts and conclusions of law that wholesale bought what Officer Gaspar said. Findings of fact. The court ignored, he entered wholesale the findings and conclusions proposed by state, ignored everyone proposed by Petitioner, including things that were clearly presented in evidence.
But those findings weren't challenged, were they?
Yes, the findings were challenged.
In the ICA, you challenged those findings?
Yes. Yes, Your Honor. Yes. Findings of fact, conclusions of law were expressly challenged in our opening brief. It was first brought up in a partial opposition to the motion to determine, and then it was brought up in the motion in limine number 2, and it was raised before the ICA.
Okay, well, let me ask you this. With regards to that hearing on the motion for voluntariness, were defense witnesses presented?
No.
There's 3 officers who testified during that.
Yes.
All right. That's what Judge Kim had before him.
Yes, and it's not defendant's burden on a state motion to determine voluntariness. And here lies the rub. It's a heavy burden. This court recognizes it's a heavy burden. After arrest, it's a particularly heavy burden. The quantum of proof under state law on a motion to determine voluntariness is more than a scintilla. Justin Gaspar's testimony at most was a scintilla. Federal standard for the quantum of proof on, again, and it's just voluntariness. I have to remind that this case is also about that screaming match that Justice Levinson, the swearing match. Federal court, it's the preponderance. In the state of Colorado, and that came forth in Connolly versus Colorado, the U.S. Supreme Court, it's a clear and convincing standard. And as we see from the amicus brief, Massachusetts, the Commonwealth of Massachusetts, has not only a beyond a reasonable doubt standard, but it's a determination made by the jury. Our law is collapsing Fourth Amendment search and seizure law with custodial statements. Mr. Zuffante and any other defendant has no burden on that motion to determine voluntariness. And to say he does and has an opportunity to testify, no, he has a constitutional right to remain silent.
But wasn't he Mirandized, and isn't that what the findings were? What exactly about the finding that this was a voluntary confession do you think, what's wrong with that finding given what the record was? The officers came in and testified, said it was voluntary. He signed the form. He signed the Miranda form. So what exactly is there that you're disputing in terms of this being a voluntary statement?
Mr. Zuffante did not challenge that he signed the advice of right statement was not under duress. No, he didn't force me. That's not what this question is about. It's not only about voluntariness. It's about what happens when there's a dispute about the content of what is said, and is the state able to prove the content of a statement by a mere more than scintilla.
Well, it's also, by extension, the key aspect in the ACLU and the Innocence Project are really the ones who raised the issue about the right to not testify, and the fact that there's an unrecorded interrogation and the swearing contest you're talking about forces the defendant to get up there and combat what happened into the interrogation room, yet at the same time opens that defendant up to cross on anything else about the case. So it's sort of, damned if I do, damned if I don't exercise on the right to testify or not to testify. I think that's your key point. But in this particular case, Mr. Zuffante got up there and testified what he wanted to testify and nothing more. And the prosecution did not cross him on anything else about the case. So how was his fundamental rights to due process tethered to the right to testify or not to testify impacted in this case?
Because under case law, establishing this quantum for the motion, under the direction of the trial court, which would have had him which would have required him to testify at the voluntariness motion, and then put a burden on him.
Require him to testify at the voluntariness, it's actually a free pass, because you're not going to be able to use whatever he says at the voluntariness hearing, right? And you didn't put him up there on the voluntariness hearing.
And that is because he has the constitutional right to remain silent unless he has to present standing, as in a Fourth Amendment search and seizure matter. This is not search and seizure. If the right to remain silent is inviolate, it has to inure through the entire proceedings, not just when the person's in custody, also through the trial, unless he has to establish standing. And there is an inherent issue with a lack of a reconciliation between a heavy burden on the state and then telling them they can meet it by a mere scintilla.
So are you really arguing voluntariness with all of this, to follow up on the Chief Justice questions? Because the waiver form was read to your client, and he signed off on each and every question of him, and he waived his right to an attorney and wanted to speak.
Yes.
So how do you respond to that? Why isn't that? I mean, that's a record. He signed it. He's not challenging that that wasn't his writing, that he said no coercion,
That's right.
knowingly, voluntarily, intelligently. Why isn't that sufficient? That is a record.
Because his challenge, Your Honor, is not to voluntariness. Although it's not really for him to decide whether or not it was voluntary. It was held overnight and not Mirandaized until more than 36 hours.
Well, what
after
more
the
was
arrest.
the officer supposed to do other than read him his Miranda rights?
Make sure he had an alternative to recording the interrogation. Maybe went and got a second officer in on the interrogation. At least that's what happened in Kekona. Kekona at
Okay,
least had
you're
two.
asking for cooperation as opposed to waiving his rights to speak with the detective. Isn't that a different question?
I don't understand. Cooperation.
No, corroboration.
Corroboration.
So the question is, are we talking about voluntariness, or are we talking about the content of the statement? Because I thought you were arguing the statement, there wasn't sufficient evidence for the court to find that it was voluntary. But what Justice Devins is saying is there was a form, it was reviewed. That's not disputed. So the real dispute is whether he said what he said in the interview room, I guess.
Yes, Your Honor. It's content.
But in terms of voluntariness, I noticed that the officer testified that initially he had actually might have clicked the box that said he wanted an attorney, but that it was corrected, and according to the officer, it was a mishap on his part. So would a videotape recording perhaps have shed a little bit more light on the circumstances of that?
Certainly. Although Petitioner did acknowledge, no, I made a mistake.
Right, that's unchallenged, right?
That's unchallenged. I
Okay.
made a mistake.
We're about 26 minutes in. Did you want to have any further points or reserve time for rebuttal at this point?
I'd like to save the balance for rebuttal, Your Honor. Thank
Very
you.
well. Thank you. Thank you very much, Ms. Yandel. All right, Mr. Makapinmak.
May it please the Court. Good morning, Chief Justice, Associate Justices, Ms. Yandel. In this case, the petitioner asked this Court to overturn almost 30 years of case law based on a premise that technology has changed, therefore the ruling in State v. Kekona was wrong. However, this is a misdirection. It's a red herring, because the issue in State v. Kekona was not whether or not the police had the ability to record an interrogation. The police did have the ability to record the interrogation in State v. Kekona. What this Court had decided, or what the question that this Court was answering in State v. Kekona, was whether or not a defendant is denied a fundamentally fair trial because there is no recording that is produced of the interrogation. And the reason why this Court had said no, it was not a violation of due process, was that there were other procedural safeguards in the form of the defendant's ability to cross-examine and to bring the circumstances of that the statement to the fact finders, either through either a judge or a jury. And in this case, this record is completely inadequate to decide, and not only inadequate, it makes it a inappropriate vehicle to try and challenge State versus Kokona.
But what if there is a dispute as to the content, as Ms. Yandel argues? Without a recordation, how can, if on cross-examination, assuming the officer sticks to his initial testimony on direct, but the defendant has a different version of what he said, how can he establish that other than by testifying and thereby giving up his right to remain silent under Article 1, Section 10 of the Hawaii State Constitution and the Fifth Amendment of the United States Constitution?
Your Honor, that's a great question, and one of the ways to do that would be to file a motion to suppress or challenge at the voluntariness. And I know that counsel had raised the issue. However, I would agree that Simmons would apply at a hearing for a motion to determine voluntariness because the voluntariness issue is by statute under Hawaii Revised Statute 626-21, and it's an implication of both a defendant's due process rights under the Hawaii State Constitutions under Article 1, Section 5, as well as the right to remain silent under Article 1, Section 10. So I think that a defendant would be safe in challenging voluntariness. However, I do understand that you also mentioned that the issue is challenging the content. And what the court had said in State v. Kaleo was that the issue of the content of a statement is an issue that's uniquely left to the finders of fact.
But how there would be no contradictory evidence, no evidence to contradict what the officer said was said by the defendant in an unrecorded interview, other than by the defendant himself testifying, right? If it was recorded, we would know what was said. We wouldn't have this shouting match.
I would agree that a recording is the best vehicle in order to determine what the content is. However, the state does argue that cross-examination in conjunction with the jury instructions sufficiently protect a defendant. By cross-examination, a petitioner would have been fully able to bring the issues of, hey, officer, you've heard of a cell phone. Didn't you have one on you? They could have raised that in front of the jury. Additionally, there is a multitude of jury instructions that let the jury know that they are the exclusive finders of fact, and simply because an officer says, hey, this defendant made a statement, you are still not required to agree that the officer is being truthful about what that statement is. And none of these jury instructions were ever argued in this case at the trial level before the jury.
The question, you said this is not a good case to address this issue, but there was a motion in limine filed by the defense, a motion to preclude the use of certain evidence, which related to the statement. So there's a voluntariness hearing and then a motion in limine. And I believe the court denied that, but without prejudice. But the court said you can raise that at trial. But in effect, isn't that a ruling that there was a resolution that Kekona wasn't going to be overruled? And isn't that enough to preserve the issue and tee it up for us to address?
Your Honor, I would disagree. I think it was still incumbent on the petitioner at the time that the question was asked and before the question was answered to raise an objection.
How is the court's ruling on motion in limine number 2 when the court said that the officer could testify and as to what was said in the interview? The court denied the motion to suppress that, the testimony regarding the interview. How is that not a definitive or unequivocal ruling that that evidence is going to come in? Why would it have to be repeated at trial? We've been pretty clear in our case law, the last one being Kobashigawa versus Silva, that once a court makes an unequivocal ruling on a motion in limine, a party does not have to reassert an objection at the time of trial. And just by calling it a denial without prejudice to what? Without prejudice to him testifying. That's not, isn't that really prejudice?
I would disagree because I understand that this may be backseat quarterbacking, but I think what could have happened is prior to answering an objection could have been made, a request to voir dire the officer could have been made, more evidence could have been developed, and then at that point re-raise the issue. And based on what was already available, there was no bar to admissibility. And I think that leads on to another point that the respondents wanted to make, that at the time of this case, there was no legal error. The state's only obligation at this point in time, before admission of Officer Gaspar's testimony, was to file a motion to determine the voluntariness of the statement. And there's been no showing that there's any kind of legal error. A motion to determine voluntariness was had. There was no subsequent motion to suppress alleging either a due process violation or that the statements of the petitioner were coerced. So
I'm sorry, can I ask you this? I don't hear anyone saying that audio video is a bad idea. No one's really saying that. And isn't it already policy or a practice with the department to record as a matter of procedure?
It is, because that's why there was an interview room that was equipped.
Right, so how much more of a burden would such a rule be where it's mandatory now? Otherwise, the statement gets thrown out.
The reason why the respondents would think that it would be bad to make it a mandatory rule is that it doesn't account for the numerous other situations that could occur where attempts to record were made, but for some reason the recording...
The Stephen rule talks about exceptions.
Correct.
Would you be okay with a rule that had exceptions such as in that case?
If the facts of this case were different, the court should come to a different outcome. However, the record as developed...
What do you mean by that?
If this were a situation where there was allegations of coercion or misconduct by police, or if there was some kind of factual dispute in terms of what the majority of the statements were, then that might lead to the necessitating of a different result. However, in this case, when the petitioner testified, the petitioner agreed, yes, I told the officer I sold drugs, and actually the explanation of how the petitioner would sell drugs was a little bit more in-depth. There was testimony that the petitioner said that he would buy a pound of meth at a time, break that methamphetamine down into smaller units of 3.5 grams, and sell those 3.5 gram units for $150 a piece. And that statement was not opposed either. The only opposition that the petitioner had at the trial was saying, I didn't say all the meth was mine, I just said everything in the car was mine.
Isn't that consistent with his defense, which is he didn't know what was in the car, and he's trying to protect his girlfriend? So why is it that he had to get up to say those things? Because he basically had to eat everything else in his statement in order to make the point that he didn't say all the meth was mine, which was from his kind of the heart of his defense. So you're kind of arguing, yeah, no big deal, but actually it was kind of a big deal given his theory of the defense.
I would argue that theory of the defense was still fully available without the petitioner testifying, because the Officer Gaspar had also admitted that the petitioner said, I don't want my girlfriend being charged. So through cross-examination, as well as the statements that are already in the record, the petitioner had everything that he needed to argue that defense without having to testify in the first place.
He had half of what he needed. The fact that he said, I'm protecting my girlfriend. He didn't have the ability to deny that that the meth in the car was his.
I think that
right? Because how much did he have in his pocket? 3.5 grams, right?
And the 3.5 grams was in a pink baggie that had matched the 10 other baggies in another fanny pack.
Okay, so that's an argument for the state, but that's actually kind of a user quantity, right? So he's got a user quantity in his pocket. He's in a car with his girlfriend, being driven by the girlfriend. His defense is, I didn't want her to get in trouble, and so he said hastily, everything in there was mine. But in order to be able to deny that he had said all the meth in there was mine, which blows that defense out of the water, he had to take the stand. Was it fair to make him take the stand in these circumstances?
I think that's an interesting question because although there is a right to remain silent, there's also an equal right to testify in your own defense. So it does cut both ways. So I would still argue that the question is, was it fundamentally unfair? Because in a trial, there's always going to be evidence presented that is going to be against either side.
Look, your position is well, there's cross-examination, and you can look at what the detective said, and maybe if the guy testifies, look at what he says. And we usually know how well it goes with juries when it's the drug dealer's word versus the police officer's word. I think generally the accused isn't too well received in that battle. But, what I think we're getting at is, doesn't fundamental fairness and the integrity of the justice system depend on getting the person's words exactly right? Because if the words were exactly right, you wouldn't be compromising the right to testify or not. And it strikes me that it's so simple to have a recording and you will have the precise words. So how is it that a constitutional rule that protects and requires in-station interrogations to be recorded, not just sort of an obvious thing to safeguard the integrity of the system?
Well, Your Honor, I can't find it immediately, but I did cite a case at the ICA. I believe it was Luciano versus California Supreme Court case. And in that circumstance, the United States Supreme Court said that the issue of due process was not necessarily about ensuring that all evidence was perfect. It was to ensure that there was at least a fair opportunity to challenge. And I understand that a recording is the perfect vehicle to challenge or to determine what's completely accurate.
The defendant's going to say, hey, look, the police officer didn't get the context, the nuances, the actual my words, or he's outright lying. You might have that situation too. And again, going back to what the Chief Justice was just saying, is that inquiry, doesn't it force the defendant's hands to have to get up there and a defendant who might not want to testify, who might want to assert his Fifth Amendment right, but his hand is simply forced because there isn't the simple recording of the interrogation?
I would disagree with that because as counsel had mentioned, recording devices are now so prolific. I think that a proper argument could be made to, if the petitioner wanted to or if a defendant wanted to, they could cross-examine and just argue about, okay, hey, officer, are you really saying
you're kind of cross-examining against something that's invisible, though, aren't you? Because you're not in the interrogation room. How are you're cross-examining something that's in the ether land?
The whole purpose of cross-examining, I understand that it's going to be a dispute of he said versus he said, but that's what cross-examination is for, to try and...
But this is a little different situation when you don't... This is a situation where there is the ability to have the precise words, context of the whole interrogation room, taking the tones, the demeanor of both the interrogator and the suspect, it's there. So why then say, well, cross can cover it? I mean, isn't that sort of averse to the truth-detecting notions of the criminal justice system?
My response would be, what if the device is not working? They believe that the device is working and it's not working.
What about, would you oppose a rule that said in police station custodial interrogations, you must both video record with audio, but also have an audio recording? I mean, why wouldn't the audio recording, a simple iPhone, be the backup? In case the video's not working.
I had raised it in my response to the ACLU, but that could potentially throw all kinds of other questions as what happens to the device. Does that device now belong to the
Right, so why couldn't
evidence?
each police department have a separate phone or separate audio recording device that they also take into the interrogation room to do an audio recording along with the video recording in case the video recording doesn't work?
These are really important questions, and I think that Justice Ginoza is correct that, this case would not be a proper vehicle. The issue should go before the legislature or a committee so that there can be...
We are being asked to construe the Hawaii State Constitution, correct. Article 1, Section 5, due process, Article 1, Section 10, the right against self-incrimination. It is this court's prerogative to determine what the Hawaii State Constitution requires. It is not for the legislature necessarily to decide, although the legislature can, of course, step in, but the legislature has not. And so we are here today with a controversy as to what was actually said in an interview that was not recorded.
And I understand Your Honor's concern, and the court does have supervisory powers to superintend the lower courts. However, under the statute 602-4, the supervisory power should be used sparingly, or more specifically.
And I'm not talking about supervisory powers. I'm talking about this court's obligation to construe what the Hawaii Constitution requires.
So, counsel's position would be that under the due process case law and under the current circumstances, recordings are best practices, but the issue is that a necessary component? And the state would argue it's not a necessary component at this time, based on the lack of showing that there has been misconduct or abuse on the part of law enforcement. So although it's a best practice situation and respondents agree that...
Wouldn't you agree that if there had been a recording which totally confirmed what Officer Gaspar said, the defendant said, we wouldn't even be here?
That is very correct.
It seems that recordings also protect the police against claims of misconduct. It actually, I think when body cameras came into play, the police might have been for it simply because it protected them. So isn't it a recording protects not only the criminal justice system, like I've been saying, but also protects police officers and the suspect? What's the problem?
I do agree that recording it's extremely useful, but the question is, does the case law necessitate
we know what the case law goes back 30 years, and the legislature has not acted, and we are deciding right now, squarely before us, a constitutional matter. So essentially, that's what we're doing. So that's we understand the case law. So can follow up with your point? I'm sorry to interject.
Well, I would argue that when you look at the facts of the case, look at all the law, the lack of the record, those in conjunction do not show that the court should create a new rule at this time.
When should we do it?
There should be an actual record showing that some kind of misconduct had occurred.
It doesn't have to be misconduct. As all the studies show, that talk about the reasons for recordation, people have different memories about what was said, or they might mishear something, right? It doesn't have to be misconduct. It could be a misunderstanding. And if there's a recording, it's clear.
I don't think anyone disputes that recordings are a perfect vehicle to decide what was said or what was not said. However, again, the state argues that the issue was a defendant denied a fundamentally fair trial. And there's been no showing that in this case, the petitioner was denied a fundamentally...
What if the recording showed that he didn't say what Officer Gaspar said, even if that's how Officer Gaspar remembered it? And I am not disparaging the officer at all. I'm just saying it could have been a mistake. What if the recording showed that the defendant's version was actually correct?
Well, I would agree that once there's an actual dispute, then that leads the court to, that should be an instance where the court should take action. In this case, again, I think that the petitioner had the full ability to present their case and their theory of the case without having to testify.
I don't understand how this defendant would dispute or be able to effectively dispute that he didn't say the meth in the car was mine. He can say the officer was sloppy, took him a week to do his report, he could have recorded it, but he didn't. All those things that might cause somebody to have a little concern about Officer Gaspar's accuracy or good faith, but I'm not saying he acted in bad faith, but that doesn't get out the key fact for the defendant, which is I did not say the meth in the car was mine, because that's sort of the linchpin of his defense. So he had to stand up there, testify, and as part of that testimony had to acknowledge that, hey, I deal meth.
Well,
that seems like in this case the defendant was pressured into making a decision to testify that is one that perhaps he shouldn't have had to make. That's the question, I think.
Well, I think even because it was a lack of recording, I don't think that the petitioner was necessarily forced to accept.
How is he supposed to dispute that? How is he supposed to get in front of the jury that, other than testifying, since there are only two people in the room, that I did not say that the meth was mine? So what's your cross-examination? Well, officer, is it possible that he said the meth wasn't, that he just said what was in the car? No, I'm pretty, that's a big deal for me, so I'm quite sure that's what he said. You sure? Yep. I'm pretty sure. Yep. Yeah, I'm sure. No, really, isn't it possible you misunderstood? No. You know, I'm a careful officer, that's what I got. Okay, so now his defense is still dead in the water.
I think the cross-examination could have gone like, oh, officer, do you have a cell phone? Do you know cell phones can record video and audio? Your friends have cell phones. Your coworkers have cell phones. There's other officers at the time. You can't find a cell phone?
I understood from your briefing that you did have concerns about officers having to use personal cell phones for recordation, and I understand that concern, right? So wouldn't that be the state's response if that had been the cross-examination? Like, oh, no, officers are not to use their own cell phones for recordation because then their personal data might become subject to discovery, you know?
Or they could have, petitioner could have taken the ACLU's cross-examination about how there are other officers who were equipped with body cameras at the time. And there was just no cross-examination or follow-up to develop the record to show that there were possible other means of recording, and then that information could have been presented to the jury to show that, to throw into question Officer Gaspar's credibility.
But I thought the officer knew that the equipment wasn't working.
The officer who conducted the interrogation was not equipped with body camera and had testified that the equipment that was usually used to record the interrogations was not working at the time of the interrogation of both the petitioner as well as the passenger.
And we still don't know whether that was video, right? That's usually used.
What's usually used is both video and audio.
It's a video with the audio component.
Usually with the police station recording equipment. However, again, we don't have a full record developing what the circumstances were at the police station at the time.
So counsel, am I hearing you right that your basic argument is that even if the Alaska rule was in effect, we tried to comply. There was just a malfunction of the device. It's an exception.
Yes. So part of my argument is that even if we were to try, which is why I think the petitioner is trying to evoke a different rule, even if this court were to apply the Stephen rule to this factual circumstance, there would not be enough to show that the statement should be suppressed under the Stephen rule itself either.
Because of the exceptions?
Yes.
Feasibility?
Correct.
Thank you.
You know, didn't the defendant actually think it was being recorded? Didn't the defendant say, hey, I thought it was being recorded because of the cameras? The police, say it wasn't feasible, is broken. Is it a voluntary statement if a defendant provides a statement believing every word that he says will be memorialized in a recording? Okay, it's being recorded. I'll tell you what's up. But then it turns out it wasn't being recorded, and now I have to I get into this swearing contest with the police officer. Is there an impact on the voluntariness there?
I don't think so, because again, the issue of voluntariness is whether or not either police or some other party was coercing an individual into making a statement. So simply because the person believes that whatever they're saying is being recorded.
Well, it's a knowing, voluntary, and intelligent waiver of your right to, be quiet or make a statement. And if that's based on my idea that everything I say is being recorded, doesn't that impact the voluntariness and the knowing waiver?
I think, again, this could have been testified to at the voluntariness hearing without waiving a defendant's right to testify in general, because that question goes to the making of the voluntariness statement. So that wouldn't implicate any kind of facts of the case. And in this situation, the defendant did not testify, hey, if I knew it wasn't recording, I wouldn't have made that statement.
Just so that we're clear, the defendant's cell phones are taken by the police when they're brought into custody, correct? So the defendant can't come in there and record it himself, right?
Yes, because they're in custody.
Right. So it's only the government that can actually do the recording.
During a custodial interrogation, yes.
Mr. Makapimlak, we're almost up to the end of your time, but I will offer you the opportunity to wrap up or bring up any last points for the court.
My last point is I would consider this issue waived because it was not brought up, and I don't think that Ms. Yandle's assertion that there was ineffective assistance to counsel is sufficient to make a finding of ineffective assistance to counsel. In order for ineffective assistance to counsel to occur, there would have to be some kind of omission on the part of an attorney that would affect the substantial rights of a defendant. And in this case, in State versus Ritchie, this court stated that failing to object to admissible evidence was not an omission. And additionally, with the current state of the law, there was, even if there were to be a motion to suppress filed on the grounds of a violation of due process, there's no case law that would guarantee that the suppression would have occurred. So I would argue that the counsel was not ineffective because to hold that a defense counsel must raise every kind of novel issue or try to overturn case law would unduly burden defense counsel, and it is not a requirement to provide effective assistance to counsel. Thank you.
Very well. Thank you, Mr. Makapimlak, for your argument. Ms. Yandle, your rebuttal.
Thank you, Your Honors. As concerns the sufficient development of the record below what trial counsel did and didn't do, at the motion on voluntariness on August 17th, 2022, on page 50 of that transcript, you will see Justin Gaspar's testimony that he says there are no procedures or policies regarding how police are to conduct interrogations in the interrogation and interview room. And then on page 33 of that transcript, he testifies, this was under cross-examination, that he conducted a joint advice of rights regarding searches contact with Petitioner and his girlfriend, requesting consent to search the vehicle, stating, quote, that way I didn't need to read it separately. On this idea that there's an obligation on the defendant on a motion to suppress this opportunity to testify, Simmons does not and should not be contaminate our due process considerations. Simmons was clearly a case where the defendant had to assert standing over a suitcase that contained proceeds of the alleged crime. In order for him to testify, he had to assert his standing, which is what a motion to suppress is. The defendant brings the motion, the defendant has a burden. The Petitioner here had no burden at that motion to suppress, and we should not be importing this, oh, you can testify before the bench and it won't be used against you. No, should not have to. The right to remain silent is inviolate. I'd like to address the issue of should the legislature handle this. State mentioned the Obrero case and how state's saying we should wait for the legislature and then mentions Obrero, but after Obrero was issued, then the legislature acted. There's another case where State v. Thompson, same jurisprudence, the statutory language clear and unambiguous, right? Remember what happened with Thompson about charging of a complaint? Has to be subscribed by a complainant or by declaration. The Third Circuit Office of the County Prosecutor is the one that led the charge up at the legislature to get rid of that, and they did. And you know what? It took them 3 months. It was Act 2 of 2022. It was the second act the governor signed during the legislative process after he signed the budget bill. So what happened there, without any regard of what I understand the prosecution went for that because you have to charge felonies by an indictment or a grand jury, but there was no thought by the legislature or apparently the Office of the County Prosecutor of what happens to a person who gets charged with a misdemeanor. They now stand before the trial court, the district court judge, with only a signature of the prosecuting attorney. So, as far as the legislature goes, we cannot wait for the legislature, and if this court were to issue a decision and the county is not happy with it, the Office of the Prosecuting Attorney, we know they can act quickly. Audio recording came up. Well, wouldn't that have been sufficient to draw this court's attention to some of your previous cases? The Baker case comes to mind. It was a 3-2 decision. Everybody heard the same tape, but came up with a different conclusion. The majority came up with improper police tactics in the interrogation that amounted to coercion. The dissent didn't hear that.
Ms. Yandel, we hit your 30 minutes, but I want to give you a chance to make any final points or to wrap up. Yeah.
Thank you very much. In conclusion, Petitioner is hoping that this, you see what he does. He was forced to testify against his will, did not have to do it, and everything cascaded from the predicate structural error in the motion to determine voluntariness proceedings. Thank you.
Very well. Thank you for your argument. The court will take this matter under advisement. We'll be issuing a decision at a future time. I want to thank Ms. Yandel and Mr. Makapinlock for participating in our argument today at the Performing Arts Center. You know, it's a stressful event to be out here in front of all these folks and on statewide television. So will you please join me in acknowledging them for a great job they did. And I particularly want to thank the about 270 students and teachers who've joined us here today from Connections Public Charter School, Hawaii Academy of Arts and Science, Hilo High School, Lapahoihoi Community Public Charter School, Waiakea High School, and we also have some students from UH Hilo. Can you please join me in acknowledging all these students? You know, the energy in the room here today and the hard work and engagement of the students and teachers is truly inspiring. And it's clear that our future is in good hands. So I really want to thank each and every one of the students and teachers for the time they put into this, as well as for the volunteer attorneys who went out to the classrooms and worked with the students. I think we had 22 of those attorneys, many of whom are here today. And that's sort of a key part of this program, is that we have the opportunity to share with the students what the case is about, and in many cases to give them the opportunity to do an oral argument of their own in preparation for today. So please join me in thanking all those attorneys who volunteered their time. We have a number of guests here today I just wanted to acknowledge. We have Mark Murakami, the President-elect of the Hawaii State Bar Association. That's the group that includes all of the licensed attorneys in the state of Hawaii. Kristen Izumi Natao, who's the Vice President, both came over from Honolulu. We're very grateful for them and for the support of the Hawaii State Bar Association. We also have the Prosecuting Attorney, Kelton Walchin. We have the Assistant Corporation Counsel, Jay Stanley Yoshimoto, and we have pretty much all of our circuit judges, both from the circuit courts, district and family courts, both Kona side and Hilo side. I'm very grateful that they came here today. And again, also as well as our court administrators. We have Chief Judge Robert Kim, who's now our Chief Court Administrator, and others who are here. And I really appreciate the work that they do day in and day out, and in particular the work that they did during the pandemic to continue delivering justice to this community. So please join me in acknowledging our judges. So just want to shout out, we have a lot of volunteers here today who've helped out. I want to thank each and every one of them. I want to thank the folks here at the Performing Arts Center for their amazing professionalism. I want to shout out to the William S. Richardson School of Law. So for those of you who are considering a career in the law, we have a wonderful law school here in Hawaii, named after one of the predecessors of the Chief Justice at William S. Richardson. 3 of the members of our court are graduates of that school, and that school is very engaged in the community. Its students help prepare the teaching materials that our volunteer lawyers use to go out into the community. And I'm really grateful. Again, it's a huge partnership between the attorneys who volunteer, between the local bar associations and the law school. So I'm very, very grateful for that. I want to shout out to just a few people: Jerry Hasagawa, Rebecca Lester, Michelle Oishi, Andrew San, and Jennifer Gazelko, who worked very, very hard to make the logistics of this event happen. I also want to thank our MC and moderator, Bill Heflin. Mr. Heflin is a really incredible contributor in so many ways in our community. So please join me in acknowledging Bill and the other folks who helped. Thank you to our wonderful judiciary staff, to everyone who helped put this event together, in particular Kurt Shibata, our bailiff, and who's came over as really, along with Kalea Kau, really made this event happen. So I'm very grateful to Kurt for his professionalism and everyone else who came over to make this happen today, as well as folks from the local court. I want to thank Naleo for helping us technically, and then really important, I want to thank the folks who provided the lunches and the buses, the Hawaii State Bar Foundation, and the water, the Waiakea Water Kokua Initiative. So mahalo to them. Please join me in acknowledging. All right, and there being no further business, the court stands adjourned. Mahalo, everyone.
E ku iluna, please rise. Ua ho'o ku'u ia mai ne kea aha. Ho'o kolo kolo ki eke hano hano o ko moku aina o Hawaii. This Honorable Supreme Court of State of Hawaii is now adjourned. Please be seated.
So, as a reminder, today's program is educational, and we would, at this point in time, kindly ask members of the public and the media to please exit the auditorium so the students can begin their program. The volunteer attorneys and Bar Association board members are welcome to stay, but all others should, at this point in time, start making their ways out.